All right, sir, you are Robert Lowe.
Yes, ma'am.
And in cause numbers, okay, so we were here before, and Mr. Lowe had entered pleas of guilty in cause numbers 19, 32661, 32666.
3 defendants, 3 completely different crimes, and 3 rulings that show how one courtroom can deliver very different versions of justice. First, a man who took explicit photos of his own niece is asking for probation. Then, a probationer admits he ignored every condition the court gave him. And finally, a truck driver who says a tragic highway death was an unavoidable accident, while the state calls it pure negligence. This isn't just sentencing day. This is where remorse, responsibility, immigration status, and public safety collide. And by the end of this hearing, the judge will deliver a hybrid sentence, revoke probation instantly, and hand down state jail time in a case that leaves a grieving family in the courtroom. The real question is, who walks out with mercy and who doesn't?
In 32662 and 32663.
Yes.
There was an agreement that you guys had reached for a 7-year deferred probation. I rejected that plea agreement. We reset it. He went back through, entered pleas of guilty in those same cases open to the court, correct?
It was a cap of 6.
Cap of 6. Sorry. Cap of 6. And it's the same 3 cause numbers as well, correct?
Yes, Your Honor.
Okay. And then the agreement was for dismissals in the remaining cases as part of that agreement.
Yes.
Is that right also?
Yes.
And we reset it after that plea without getting a new pre-sentence report. We've already all gotten the pre-sentence report, reviewed that. Is that correct?
Yes, Your Honor. And we received a memo. Well, it's the same pre-sentence report. We just have an updated memo from the mother of the
Victim.
one of the people that he had photos. One of the children.
Yes. Okay. And I reviewed that as well. Did you have an opportunity to review that?
I do not see, well, give me just 1 second.
Yes, ma'am.
Sorry. Okay, Judge. I've reviewed that in the original PSI. Obviously, the court is aware I was not involved with offers in this case.
Okay. Thank you, ma'am. Any reason not to go forward now with sentencing?
No, Your Honor.
All right. Ms. Holmes, you may proceed.
Yes, Your Honor. We are still requesting that the court consider probation in this case. We do know, obviously, the offer of deferred probation was rejected, but we would like the court to consider possibly straight probation in this case. Mr. Lowe does not have any previous criminal history. One of the victims or complainants in regards to photos was his niece, in which I have been in touch with her mom, who is Mr. Lowe's sister, Brittany Lowe, in which I'm aware, the court is aware that they both submitted statements in which they are requesting that it appears that he'd received some type of probation, in which they're not requesting that he be sentenced to time. But they are obviously requesting if there's a no contact, which we believe is appropriate, and any other stipulations. So, Your Honor, we are asking that the court consider straight probation possibly, maybe the 6 years probated for 10 years, just to make sure that Mr. Lowe has a watchful eye on him to show that he can abide by the rules and regulations of the court. This offense did appear to be back in 2018. I will say to Mr. Lowe's credit, it doesn't appear that he'd have been in any trouble since that time. There were no new cases filed or anything like that. So I would say to his credit, within the last 7 years, that he has not committed any additional offenses. He does take full responsibility for his actions in these cases, and he's aware of what the possible maximum punishment will be. But I do believe that he can stay on the right track. The plan, if released and placed on probation, and that he will continue to live with his mother, who's 80, in her 80s.
I'm sorry, she's 73.
73, okay. She calls me quite a bit. But the plan would be for him to reside with her, which there are no children in that home. His sister and nieces, nephews live in separate locations. And so we're just asking that he be given that opportunity.
Ms. Malfino, I know you're just stepping in. Obviously, I have a lot of information that I've gone through with all of this. Do you have anything to add?
No, Judge, other than certainly I'm understanding of the court's hesitancy for the original probation offer, which makes it difficult for me to stand and argue for probation at this juncture. I appreciate the statements that they emailed in. However, due to the nature of the offense, my position would probably have to be pen time, Judge, or in lieu of that, maybe some type of a hybrid, whereas he goes to the pen in one and is on a lengthy probation on another. I know the court's
You read my
not
mind.
your favorite thing. So, based on everything you know, Judge, I'll defer to what you think is best.
Okay, thank you, Ms. Malfino. So I do want to make sure we're all on the same page, and I have done different types of hybrid sentencings before. But the first thing I want to make sure is everybody agrees with me legally that if I give probation on any of the cases, straight probation, that I can then give a 10-year sentence probated for 10 years, for example. Because it's probation, then that cap at the end, we've looked into that. So I want to make sure everybody understands and agrees with that.
Right.
So, Mr. Lowe, you know, I've already gone through when we were here for sentencing before, obviously my issue with the plea agreement and the fact that it wasn't, not that possession of child pornography is in any way okay, it's not ever, but the fact that you actually took pictures of your own niece is the problem that I have. The initial version that you gave, it sounds like you finally came around and told at least somewhat of a truth, but the initial version of I was trying to protect children is just ludicrous, and makes no sense at all. So that gives me some great concerns. Obviously, if I just gave you prison time, I don't know that that gets me where I would like to be, because I think you need some treatment as well as probably some time, both. Because I want everyone protected if you are out or when you are out, because you'll get out of prison. So what I'm going to do in your cases, in cause number 19-32661, find that you entered your plea freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of possession of child pornography. I'm going to sentence you in that case to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 19-32662, also find sufficient evidence to find you guilty, and in that case find you guilty of possession of child pornography. Sentence you in that case to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to probate that and place you on probation in that case for 10 years. In that case, I'm going to order a $1,000 fine and that you follow all of the rules and conditions of probation, which I'm going to talk about in just a few minutes. And then in cause number 19-32663, also find sufficient evidence to find you guilty, and at this time find you guilty of possession of child pornography. In that case, sentence you to a term of 10 years in the institutional division of the Texas Department of Corrections. But I'm going to suspend that and place
Pause
you on
right here, because this is a legally strategic move by the court. What the judge just did is called a hybrid sentence. She imposed 5 years in prison on one count, and then probated 2 separate 10-year sentences on the other counts. That's powerful. Why? Because probation in those 2 cases allowed her to increase the exposure from the previous 6-year cap to a full 10 years. In simple terms, if he violates probation after release, he's not facing 6 years, he's facing 10. Already pre-sentenced. No negotiation. No reset. And notice what she emphasized. Sex offender treatment is mandatory. No misclasses. No second chances. She's structuring this not just as punishment, but long-term supervision and control. This is a judge balancing 2 goals: incarceration for accountability and probation for monitoring. Do you think 5 years is enough prison time in a case involving photos of a family member? Or should have been straight time across the board?
suspend that and place you on probation for 10 years. You'll be ordered to pay a $1,000 fine in that case and to follow all of the rules and conditions of probation. So here's what that means. First of all, you're going to do the 5 years first. Whenever you either finish that 5 years or make parole in that case, you're on probation in the other 2 cases for 10 years. And when you're on probation, what'd I do?
It's not, it's 32663. That one, it's not that one.
60, 61, and 62.
Yes. It's 32660.
Oh, the PSI is wrong. So the very last case that I just finished you on, which was 19-32663, I'm going to withdraw that. That was actually cause number 19-32660. And in 32660, I find sufficient evidence to find you guilty, and at this time find you guilty of possession of child pornography. Sentence you to that 10-year term. It's going to be probated for 10 years, $1,000 fine. So with regard to those probations, once you're out of prison, you will be required to go through sex offender treatment. It will be a part of your probation. If you don't successfully complete that, participate in that, then it's going to be a violation and you're going to be right back in prison. And on those 2 cases, because I gave you probation, I was able to now give you a 10-year sentence instead of a 6-year sentence. So if you get out of prison and you get on these probations and you violate them, you already have a 10-year sentence. Do you understand? So whatever probation requires of you, but most specifically the sex offender treatment part of this, you will be required to do. And if you violate, there's not going to be any second chances for not showing up to your classes or anything like that. My goal is going to be protect everyone around you and hopefully make it to where you have the treatment needed to where we don't have this issue again. Part of your probation will also be in each case that you're not going to be allowed to be around any child under the age of 18 unsupervised. And so you can't live with anybody that has children. You can't be, again, unsupervised with any child under the age of 18. Do you understand? All right, I'm handing you in all 3 of those cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal in all 3 cases. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right, good luck to you.
Can I ask something?
Yes.
The no contact with no unsupervised, can we wait till after treatment's completed and just be no contact?
Yes, so there'll be no contact with any child until the treatment is completed. And then after that, it would be as long as it's supervised. Okay? All right, go back with the bailiff. Mr. Lewis, did you work out something on Elijah Miller?
I need to print it and swear in.
Okay,
Then I'll send it to you. Elijah Miller.
and Mr. Gertz, I'll get to you as soon as we're done with that one.
The ledge is gonna ask for a reset if you want to just go ahead and reset. She's gonna be back down, she's 79.
I'm in no hurry.
Okay, thanks.
Plus I was late, so I don't Yes, ma'am.
I know. Yeah, that's Delage.
Oh, okay. I didn't know I saw her walk out. Jones and Collins. Is that still set?
All right, this is, are you, sir, are you Elijah Miller?
Yes, ma'am.
And Mr. Lewis, will your client waive the formal reading of the indictment?
He does. And it's MTRP.
Thank you. No, it says it. And will your client waive the formal reading of that motion?
Does.
Okay, Mr. Miller, in cause number 23, DCCR 0403, I have a motion to revoke your community supervision. Shows that you were placed on probation June 26th of 2024 for the state jail felony offense of burglary of a building, and that was a 2-year term in the state jail prison that was probated for 5 years. Is that correct?
Yes, ma'am.
This motion alleges that you violated your probation. Count 1 alleges that you failed to report as directed, ever after receiving your probation. Is that true or not true?
True.
Count 2 alleges that you failed to report by mail since receiving your probation. Is that true or not true?
True.
Count 3 alleges that you failed to immediately report to the probation officer your correct address and contact information. Is that true or not true?
True.
And then finally, count 4 alleges that you're behind in your court-assessed fees. And is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 4 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're all actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1,
No objection.
it's admitted. Is there any evidence that Mr. Miller's not competent?
No judge.
Let me look back at something real quick. Whatever happened with that probation that you were on in Orange for evading with a vehicle?
That was revoked and he was sentenced to 2 years TC.
Okay. All right, then I'm going to find, Mr. Miller, that you entered your pleas of true to counts 1 through 4 freely and voluntarily. Find those counts true, find sufficient evidence to revoke your probation, and at this time, revoke your probation, reassess your punishment in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. And when I first sentenced you to this probation, you were given the admonishment regarding not possessing a firearm, correct?
Yes, ma'am.
Okay, so make sure you remember the conviction was back in 22-24. You were ineligible to possess a firearm in Texas because of that, okay? All right, good luck to you, sir. You can go back with the bailiff.
Thank you. You have a good day.
Thank you, sir. You too. Yes. Okay. Mr. Gertz, you have Vishal, or no given name Vishal? This is Mr. Coleman.
Yes, Judge. You don't have to participate if you don't want to.
Good morning, sir. Are you Vishal?
Yes, ma'am.
And this is cause number 25 DCCR 0507. Mr. Vishal was previously in court, entered a plea of guilty to the state jail felony offense of criminally negligent homicide. This was unagreed. The plea was. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Judge.
State has, Judge.
Are there any additions or corrections to the report?
Not from us, Judge.
Not from the state, Judge.
All right, then, Mr. Gertz, you may proceed.
Judge, we're asking the court to consider probation. This case is unique, I would argue, for a variety of reasons. First and foremost, this court is very familiar with me and my proclivities. I would try this case 100 times out of 100. When I walked in to talk to him the first time, he said, I want to accept responsibility. That almost never happens. He didn't shirk his responsibility. We can talk all day about the fog. We can talk about the Tex dot needs to get their act together with the shoulders on the highway, whatever we want to talk about. He wanted to take responsibility. And he said it from the first day. When was the last time you ever saw me come in and plead on the first hearing, plead guilty to a serious offense like this? Never. He wanted to do that. That was him wanting to do that. And so from that standpoint, it's a unique case. The other reason it's a unique case is there's no aggravating factors here. He's not intoxicated, he's not on his phone, he's not doing anything other than driving his vehicle. Now, what happened to these people in the end result is absolutely tragic. And again, he's taking full responsibility for that. But I will tell you, Judge, if he'd had 5 more seconds notice, he wouldn't have been able to stop the vehicle. It had 10 more seconds notice. He wouldn't have been able to stop the vehicle. He's doing the speed limit. He's driving on the highway, and there are vehicles on his left and behind him, and there is a stopped vehicle on the interstate. I mean, there's not a scenario in which maybe the injuries are less, but there's not a scenario in which this accident does not happen. And so, again, he's saying, I should have been more careful. I could have done other things. I could have fixed this. And the way he's saying that is with his plea and also his statements here. He expresses deep remorse. He struggles to sleep at night. He feels guilty about what happened to these people. And again, there's nothing redeeming about the outcome for these decedents, these victims. But the reality is...
This is where the temperature in the courtroom changes. The defense paints this as a tragic accident. Fog, highway shoulders, unavoidable timing. The prosecution pushes back hard. Clear weather, moving vehicle, dash cam footage. No traffic blocking a lane change. That's not an accident, that's negligence. Then the state introduces 2 powerful emotional elements: immigration status and a 16-year-old victim's obituary. And legally, the judge can consider unlawful entry during sentencing. It's not about politics. It's about overall character and compliance with the law. But here's the tension. Criminally negligent homicide is a state jail felony. The maximum available sentence is only 2 years. The prosecutor even admits frustration at that limitation. So here's the big question for you. Should sentencing focus purely on the driving conduct, or does immigration status properly factor into the court's decision?
This is a situation that is a terrible, tragic accident. He is trying to take responsibility. I think that is, again, at least from my standpoint, is somewhat unique. And I'm asking the court to at least consider the distinct possibility and the option here that you have to grant him deferred adjudication probation. He would give up his driver's license, he'll give up his CDL, he'll do whatever the court orders in order to comply with probation. But putting him in the state jail for, another year and a half is not gonna fix anything. It's not gonna make it any better for these decedents. It's not gonna make it any better for their families. It's not gonna do anything to anyone other than just cause him to not be out in the world for a year and a half, and that's it. And so this court could supervise him, this court could oversee his continued acceptance of responsibility, and also protect the public at the same time. So we're asking the court to consider doing that, and that is our request.
All right, thank you. Mr. Coleman,
Thank you. I'll be brief.
I'm sorry. Are there any holds? No.
I'll be
Go
brief,
ahead.
Judge. Mr. Gertz and I agree on one thing, that I, like him, would try this case, as he puts it, 100 out of 100 times. Myself, Judge, this is no accident. This is pure negligence, as it is the definition of negligence. I'll spare the court. I didn't showing the court the video. The tractor trailer that this defendant was operating that day was equipped with dash cam, or a version of dash cam video that shows that the vehicle that he struck was not stopped. It was traveling at a slower speed with its hazard lights on, but it wasn't stopped. There was no fog, the conditions were clear, and there was no cars on the other side of this tractor trailer rig, preventing it from even changing lanes. I have the video. The court, if it desires, can certainly watch the videos. Short clip. But Judge, I take issue with that recitation of how this all went down. I'd like to offer State's Exhibit 1. It's a certified copy of FBI records indicating that
Make
this
that
defendant...
2.
Make it 2?
Because states 1 would have been the plea papers.
All right.
And we have no objection to it.
It indicates, Judge, that this defendant illegally entered this country and he's a national of the country of India. Judge, I'm not here to make some type of a political statement or commentary. I'm just simply saying that it is a violation of federal law to enter this country illegally. And Judge, like any other violation of law, in any other case, you can take that into consideration in sentencing this defendant. I'm asking you to take that into consideration in this case, Judge. So here's States 2.
No objection. States 2 is admitted.
Judge, I also offer State's Exhibit number 3 pursuant to a business record affidavit that's been on file. It is a photo of the victim in this case, Judge. 16-year-old victim in the short obituary of her young.
No objection to it.
States 3 is admitted.
Judge, she was 16 years old, Judge. She had, at the dawn of her life, she'll never get to graduate high school, get married, do the things that people do. Judge, you can say today by your verdict just the amount of damage and harm this defendant has caused due to his negligence. I'll conclude with a couple other things, Judge. This defendant went on to continue to live his life as business as usual in California after this accident, while the investigation played out. After the investigation and the indictment, it took some effort on the part of our office in conjunction with the U.S. Marshal's office to track down and locate this defendant. I'm not saying he was intentionally hiding or absconding. I'm simply saying it took a lot of effort by federal law enforcement authorities to track him down, Judge. And also this business about this name and the alias name and whether or not he goes by no name given or goes by Bishaw. Again, the court can infer whatever the court wants to infer about why an individual would illegally enter this country and use at least one or maybe 2 different aliases, Judge. I'm asking for the max, and I am frustrated at the fact that all I can ask for is 2 years in this case, Judge. But I'm asking for the 2 years. In this case, I think this case warrants 2 years. Judge, if the court is not inclined to give it 2 years, I'm asking that the court deny the discretionary jail credit pursuant to my motion that I filed under Article 42A559 of the Texas Code of Criminal Procedure. Judge. And lastly, the family.
Say what you just said again?
It's in my motion that I filed, asking that the court deny the discretionary jail credit for state jail offenses.
Oh, okay.
It's 42A559C of the Code of Criminal Procedure, Judge.
Okay.
And lastly, Your Honor, the family's here for whatever, for what that's worth, Judge. And I believe that the mother of the deceased would like to make a victim impact statement.
Thank you, Mr. Coleman. So it's my understanding that there is, at this point, an immigration hold on Mr. Vishal, correct?
Yeah, that's my understanding too, Judge.
Okay. So even though it's likely for him to be deported because he's here unlawful, you're asking for probation?
Well, Judge, there's not really another option, right? So I guess the question is, given the current status of our immigration situation, I have no idea how ICE is going to handle this. What an ICE hold means is that if you give him probation, they've got 3 days to come pick him up. And if they don't come pick him up, then he's placed on probation. And what the court can then do is supervise him unless and until the federal government comes and deports him or attempts to deport him. The kind of alternative to that is he can sit and sleep on a cot that we're providing and, eat food that we're providing and then be deported at the end of that. With a conviction or a deferred adjudication, he's going to get deported at some point anyway. So it doesn't really, the court, I'm not trying to be difficult, but this court's decision is not going to change the likelihood of his deportation, because a deferred will count as a conviction for deportation purposes. A conviction will count as a conviction for deportation purposes. So, again, we're asking the court for probation because of his acceptance, again, of responsibility here in this case.
All right. And I appreciate the acceptance of responsibility. I do. I appreciate, and I'm sure the family appreciates, not having to go through a trial and see what they had to live through over again. And so I will take that into consideration. Probation, to me, in a felony case, really of any kind, when someone is here unlawfully, doesn't make any sense. And again, I'm with Mr. Coleman. I'm not here to make a political statement on any of this, but if you're here unlawful and you've committed a felony offense, it just doesn't make sense that I would put somebody on probation where they're potentially still a, threat to the safety of our citizens. And the no name thing gives me some concern. Also, I feel like that is just potentially an attempt to avoid probably some issues with immigration and some issues with potentially this case. So what I'm going to do, again, I appreciate, and I'm sure the family appreciates, not having to go to trial. But I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of criminally negligent homicide. Sentence you to a term of 20 months in the state jail prison. You will receive, I will give credit on that for any time that you've been in custody that the law gives you the right to receive. With regard to the state jail credit, I leave that up to the state jail authorities, and I'm going to deny the motion to deny that credit. That will be up to Mr. Vishal in state jail. With good behavior, he'll get that credit just like everybody else. So I'm not going to deny that. It's based on, always has been based on how you behave in the state jail prison. And so just to deny that, it goes against the nature of that rule and that law, so I'm not going to do that. I'm going to hand you the trial court certification that shows there was no agreement, which means you do have
Today's
a right.
courtroom showed 3 different philosophies of justice in action. In the first case, the judge delivered a hybrid sentence: prison followed by strict probation, emphasizing treatment and long-term protection of children. In the second case, probation violations led to immediate revocation and a 12-month state jail sentence. No drama, just consequences for ignoring supervision. And in the final case, the court rejected probation entirely for criminally negligent homicide, sentencing the defendant to 20 months in state jail while declining to strip him of standard good time credit. The judge made clear immigration status and identity concerns mattered, but she also followed the law as written regarding jail credit. Each ruling balanced remorse, public safety, and legal limits differently. So now I want to hear from you. Did the judge strike the right balance in these cases, or would you have sentenced differently? If you found this courtroom session as intense and thought-provoking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Which means you do have a right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that to determine what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Gertz. Good luck to you, sir. Thank you, Mr. Coleman, Mr. Gertz. Okay, did Ms. DeLage?
Yes, there was a matter of the victim.
Oh, I'm sorry. Yes. If y'all will have a seat. Mr. Kimler, can you move for a second so they can use that table? You can just have a seat over here and we'll go off the record for the victim impact statement.